Good afternoon. I'm Christian Osterman. I direct the History and Public Policy program here at the Wilson Center, and it's a great pleasure to welcome all of you and our distinguished panel to the Wilson Center and to this History and Public Policy program roundtable discussion on archives in wartime from World War II to the invasion of Iraq. Most of you are familiar with the institution that you're at right now, but let me just, for those who are not, let you know that the center, of course, was established by an act of Congress in 1968. It's our nation's official living memorial to President Woodrow Wilson, founded to honor and build upon his legacy as a man who bridged the divide between scholarship and public policy. Today we're discussing an issue which indeed straddles that divide, an event very much in line with the goals and mission of the center. As we shall see, the seizure of archival records in war raises significant questions related to military strategy, international diplomacy, and of course, scholarly research. The event is within the History and Public Policy program that I direct. Many of you are familiar with the Cold War International History project. We have several other projects running under the History and Public Policy program, but let me just mention the Cold War project, which of course for the last 20-some years has collected, translated, published and disseminated in all sorts of ways documents from the former Communist World Archives, tried to push the envelope on transparency and access to documents and to facilitate discussion of these new documents and their significance and ramifications for scholarship as well as current policy issues. Let me mention that we have been in the process over the last couple of years of digitizing, thanks to a Leon Levy Foundation grant, digitizing our entire collection, much of which sits upstairs in file cabinets. Only a fraction has so far been published through our Cold War International History Project bulletin and the website, and we're in a massive effort to digitize and make all of these documents available online through a brand new digital archive. There's further information outside on the digital archive. The entire effort, and in fact this workshop here today, has been spearheaded by not so new, but in many ways still for me, a new archivist and catalog specialist that we were able to bring on board some months ago, Laura Deal, who's really been the driving force behind this effort and also has been behind putting today's panel together. So thanks to Laura and the rest of my team for making this event here today possible. From the earliest days of the invasion of Iraq, 2003, the United States forces seized official government records created by Saddam Hussein's regime, using them for on-the-ground military intelligence. Millions of pages of these Iraqi state records have been transferred to the United States for further research. Digital copies were even made available to scholars, providing a wealth of new insights into the recent history of Iraq and Saddam Hussein's regime. The Cold War Project, the Wilson Center, in fact, last fall organized a major international conference on some of these materials together with the CRC at National Defense University. I think Laurie Fenner, the director, is here today. We have made an effort to facilitate the dissemination discussion of these materials, and our hope is that today's workshop will be a contribution to this larger effort. The continued storage and use in the United States of these Iraqi records, of course, has remained controversial, no doubt. The Iraq National Library and Archive has repeatedly demanded the immediate return of all archival materials captured during the war, arguing that these records are an inalienable part of Iraq's national heritage. This debate has been very contentious at times in the news, and we thought that perhaps what is needed is a little less heat and a little bit more light. And so this discussion today will examine the current controversy in light of similar seizures which occurred in other wars. Throughout World War II, huge caches of official records were seized by opposing forces and moved all over Europe, some repeatedly changing hands before the war's conclusion. In the aftermath of the war, the United States archives contained files from Germany, Japan, even the Soviet Union, most of which were not returned until decades later. Other examples, of course, include materials captured during the Korean War, which are still held in the National Archives, as well as records from the Noriega regime seized in the 1989 invasion of Panama. So there's a history here that we'd like to look at today, and to look at the Iraqi materials in a comparative historical view. For that, we have a amazing, wonderful panel of experts here today that will look at cases across history from a variety of perspectives, not just a scholarly and a historian or an archivist perspective. And to chair this panel, we've landed a coup by bringing back our alumna, Trudy Peterson. She will chair this afternoon's event. She's rarely in this town. She's usually on the road to some exotic place, hunting down some archive or records or trying to facilitate their preservation and access. She is a consulting archivist whose past roles have included archivist for the United Nations High Commissioner for Refugees, executive director of the Open Society Archives in Budapest, acting archivist of the United States. She also currently chairs the International Council on Archives Human Rights Working Group, as well as the Working Group on Standard Access Principles, which is developing new international guidelines regulating open access to archival records. She consults, as mentioned, at archives around the world, including most recently in Lebanon and India. She's told me she's now off to the Marshall Islands in a few days. She has published a number of articles on all of these subjects, a book on the management of Truth Commission records based on her stint here at the Wilson Center as a public policy scholar, as well as articles on conflict records and the Iraqi records controversy in particular. So she's eminently qualified to chair and contribute to this afternoon's discussion, and she will introduce our other distinguished panelists. So Trudy, it's over to you. Thanks to all of you for joining us this afternoon. Thank you all, and I think we all can look forward to a fascinating panel, and I apologize that I have to duck out a little early for meeting up with the president. Thanks.
Thank you, Christian. Thank you, Laura. Thank you, Wilson Center, and thank you all for being here. The topic we're talking about today is probably as old as the history of military and writing. We're going to be talking about World War II to the present, but of course one of the huge seizures of archives was Napoleon's. And as you will learn, there were Japanese seizures of Korean records at the beginning of the 20th century. There were French seizures of Korean records in the middle of the 19th century. This is a worldwide phenomenon, not just a U.S. and not just a period from the Second World War to the present. What we want to do today is to ask each of our panelists to talk for 5 to 7 minutes, and we've given them a question that we would like them to answer. Then I'm going to give them a chance to ask each other questions, and then we'll open it up to you. This is truly to be a discussion, not a set of papers. We really want this panel to be discussing with you. I talked with them before we came up here, and they said they'd also like to ask you some questions. So we've got a lot of things to cover. The first question we're going to ask is we're going to ask to Douglas Cox. He's an attorney and an associate law professor at City University of New York. And his research focuses on the intersection of information policy and national security. He previously practiced law with an international law firm in London and New York. He's represented detainees at Guantanamo Bay. He previously worked in military intelligence for the U.S. Army. He has written several very important pieces on law of archives and seizure, including one in the Catholic University Law Review on records and archives in armed conflict, international law, and the current debate over Iraqi records and archives. If you only read one article on the Iraqi records, read Doug's. He has a brand new one just coming out right now from the International Journal of Cultural Property called Inalienable Archives, Korean Royal Archives as French Property Under International Law. With that background, I don't think you're surprised to learn that the question we've posed to him is, what is the legal framework under which archives can be seized in the time of war, and what are the responsibilities, if any, of the seizing country to return the archives to their country of origin? Doug?
Thank you, Trudy, and thank you to the Wilson Center for inviting me and hosting this event. I think that the best way to briefly outline the legal regime for archives and armed conflict is to think of it as a general rule along with several complicating factors. And first, as an initial matter, the relevant body of law is the law of armed conflict, which is formed through treaties and conventions, including the 1907 Hague Convention, the 1949 Geneva Convention, and for records that might constitute archives and cultural property, which I'll return to in a second, the 1954 Hague Convention on the Protection of Cultural Property in the Event of Armed Conflict. Added to these conventions and treaties are also those principles that are accepted as customary international law. So what is the general rule? The general rule is that states in an armed conflict can seize the enemy's property when military necessity requires it, or in the more modern formulation, when that property constitutes a military objective, which basically means property whose seizure would make an effective contribution to military action. When you think about records and the enemy's state records, those almost invariably are going to constitute military objectives, and in fact are often a primary objective of military action. Exploiting and capturing the enemy's records is a primary purpose of military intelligence. The other general rule is that property that is lawfully captured, enemy property that is lawfully captured during an armed conflict, generally can become and convert into the property of the capturing state. That's the general rule, and that rule, when applied to something like state documents, which have a lot of different forms of value, can be particularly harsh. But that is the general rule, and there's a couple of complicating factors that I want to explore in just a little bit of detail. First is the nature of records and archives. Some records, some state records, can be of exclusively cultural and historical value, and for those records, the law of armed conflict provides special protections as cultural property. And this is a situation where I think some of the debate and argument over the Iraqi records gets stuck a little bit, because there is a tendency to, on one side of the argument, to see that as the general rule, and that because records, if records have cultural property or historical value, they should be protected. When, in fact, the tricky thing about records is that the same records that can have cultural and historical value can at the same time possess military and intelligence value. So there's a dual value to the same records. And what happens in this situation is, and this is recognized by explicitly in the 1954 Hague Convention on the Protection of Cultural Property, is that it provides an exception to its protections in the case of imperative military necessity. There is also an argument, mostly in the archival community, about the idea of archival inalienability, which is based in part on a long series of historical peace treaties in which, following a conflict, those records that were seized are transferred to the country that controls the territory to which those archives pertain. There is certainly this practice, and this practice continues in that records that are seized and awarded are eventually returned, but it's difficult to nail down that that would be necessarily a binding custom, given that it is not always followed, and it's also sometimes represents the relationship between the victor and the vanquished following a war. Often those were annexation treaties where one country would take part of another country, and as part of that defeat, they would negotiate a peace treaty. They would say, and you're going to give us the archives that correspond to the area that we just took from you. The second complicating factor that I want to touch on is the nature of the conflict. And here, there's a lot of technical issues that really make assessing any given situation very complex. There are conflicts, there are situations in which there are military operations with troops on the ground seizing records in foreign countries that are not technically armed conflicts, and the law of armed conflict is not triggered. An example of this is the U.S. in Haiti in 1994. There are also situations in which the international community can condemn an invasion as an illegal aggression, which can also have effects on the application of the general rule of property seizure. And the example here is Iraq invading Kuwait in 1990. As a result of UN condemnation, the UN requires Iraq to not only repatriate or compensate Kuwait for property that was seized, but that requirement applies even to property that would have been of military value, that would have constituted military objectives under the law of armed conflict. And the most tricky thing is that the nature of the conflict changes. It can change in phase, and it can change over time. And here, turning to the Iraq situation, Iraq is a perfect example. This is where the other side of the argument over these records sometimes also gets bogged down, which is it is tempting and pleasingly clean to say, okay, well, we've seized all of these Iraqi records, and the general rule should apply, and therefore these might constitute or could constitute U.S. property, which would obviate any obligation to return them unless we choose to, as a matter of discretion. But it's not that clean. It's the records that were seized in Iraq fall into several different buckets. And let me just walk through that very briefly. In March and April 2003, the United States was in an international armed conflict with Iraq. And the general rule generally applied. Sometime in April, but no later than May 2003, we entered a phase of belligerent occupation in which slightly different rules apply, because there can be seizures of documents for ongoing hostilities, to which the general rule might apply, but there can also be seizures and taking control of documents simply for administering the occupation, to which a different rule might apply. The situation in Iraq gets even more complex in June 2004 and after, because in June 2004, legal sovereignty was passed back to the Iraqi government. And after that date, the United States was not in an armed conflict with Iraq, and in fact, Iraq was our ally in what is generally considered a non-international armed conflict with anti-government insurgents. So records that were seized during that period fall into yet another bucket, because if you're seizing documents that belong to the Iraqi state at a time when we are essentially an ally of the Iraqi state, it creates sort of an interesting situation. It's kind of like agreeing to help pick your neighbor's garden and then taking all the carrots home that you pick. I think that the final thing that I'll just close with is that to make the rather predictable prediction that these sets of captured records and their return and the circumstances of their return is going to be determined largely by diplomacy rather than law, although those two are intertwined. And I'll end with a quote that captures how some of that works, and is sort of a quote that I think captures some of the some of the issues together, which is from General Halleck, who was the chief of staff of Union forces during the U.S. Civil War, who in a 1861 treatise that he wrote on international law actually distinguished archives even from pieces of art and other cultural property. He was less concerned about the seizure and taking of things like paintings and museum pieces. And he was more concerned about archives. And he said that, and I'm summarizing, he said that seizing, U.S. Forces can seize records of the enemy for hostilities and while they're occupying, but he argued that they should return those records when they've ceded that territory back. And his very strong words were, only a cruel and uncivilized enemy would think of withholding them. And his argument wasn't that it was technically required by international law. His argument was that withholding records in that way creates an animosity over time that will extend long beyond the period of war, which I think is a piece of wisdom that's certainly relevant to the larger discussion.
Thank you, Doug. Now we're going to start looking at specific examples, and we're going to start with World War II. Tim Mulligan is with us. He worked for more than 30 years at the U.S. National Archives as a specialist principally in captured German records, but in captured records generally. He coordinated the filming and returning to Germany of nearly all the remaining original German records from World War II that were in the National Archives custody. He's written books on it, he's written a lot of articles on it, but also he is one of the experts on Das Boot, the famous film of the German submarine. And when the film came out, Tim was one of the most popular people you've ever met. So what we've asked him to talk about today is the fact that during World War II, the U.S. did capture very substantial quantities of German records, as well as the records Germans had seized from other countries. And we'd like him to talk about the return of those materials to the countries of origin. What were the political considerations involved, especially as Doug has just said, law is one thing, but diplomacy is another, and what access is there now to the captured records?
Thank you. And thank you for the invitation from Woodrow Wilson Center to be here. And again, I apologize that I'm going to have to read my comments because that's the only way to stay on point, covering a process that was over 50 years, about 55, 58 years, and actually it's still not finished. I'm going to focus on the German records, but I will refer in part to some Soviet records as well. When vast quantities of German records fell into Allied hands in 1945, there was no plan for their ultimate disposition, and certainly not for their eventual return to German custody. The immediate Allied needs at the time for these records involved scientific, technical, and military intelligence and the prosecution of war crimes. About 27,000 cubic feet of captured materials, mostly military in nature, were physically transferred to the United States after the war, and probably a like amount went to Great Britain. Nevertheless, the earliest return of records occurred in 1945, when those of the German Railway Office in the American zone were given to its post-war successors to try to get the trains back in operation as quickly as possible. In 1947, the Office of Military Government for Germany, U.S., or OMGUS, established an interdepartmental committee to recommend disposition of captured records that were still in Germany under OMGUS control. And their final proposals in 1948 also provided for a partial return of Nazi Party, some Nazi Party, and denazification records to local German authorities. But with the establishment of the Federal Republic of Germany in 1949, restitution of records assumed a new political urgency. The next year, the Bundestag passed a bill calling for the return of the records. The senior German archivist approached the International Council of Archives on the subject, and Chancellor Konrad Adenauer formally requested a return of materials from both the British and American governments. This did result in the rather hasty dispatch of German Foreign Service personnel records from London, but it failed to move the relevant U.S. Army authority in Washington. In February 1951, the chief of the Army's Departmental Records Branch, Sherrod East, rejected any large-scale restitution of German records, stating the West German government or any other former enemy government has no recognized rights, moral or legal, in any captured military records. He went on to justify this by saying, if we were to return the captured military records to Germany, it would undoubtedly lead to an increase in German militarism. Just as to return the original Nazi Party records to German custody would obviously lead to a resurgence of the Nazi Party. The problem, of course, lay in the fact that other U.S. Army officials were simultaneously arguing in favor of creating a new West German army. So at some point, these views were going to have to be reconciled. And that occurred in October 1952. Apparently, the State Department brokered an agreement with the Army, with the National Archives, the first time my former agency became seriously involved, and the British on the restitution question. The policy paper that was produced as a result of this agreement agreed in principle with the general return of captured records to Germany, but exempted three categories of records. First, military intelligence and cryptographic documents that were important for American national security. Second, materials relating to the German occupation of other states, many of those records which were already in the process of being returned to those governments by the American and British authorities. And finally, records that glorified the Nazi regime or dealt with the organization and operations of the Nazi Party. And it's this last category that explains the existence of the Berlin Document Center, which remained under the operation of the State Department until 1994. So someone did listen, at least in part, to Sherrod East. The October 1952 policy paper, however, did not set a timetable for the return of any materials, and very little was returned through 1954. A key development occurred in 1955-56 when the American Historical Association, through its Committee on War Documents, began what would become a systematic microfilming and description of the declassified captured German records. It was that promise of retained microfilm copies in the United States that facilitated the physical return of the originals to the West German Bundesarchiv, a process that only began in bulk in 1958 and was effectively completed in 1968, excluding, of course, those exempted categories I mentioned earlier. And ironically, again, Sherrod East's prophecy would come true because the more military records we returned to West Germany, the larger the West German army would grow, but not quite in the way that he thought. An efficient division of labors kept the process running smoothly. The Army shipped the originals back. The American Historical Association's filming and description project was gradually folded into the National Archives in 1961, as were the microfilm copies that had been made and the exempted categories of original records. Collectively, these materials, with some captured Japanese records and then later the Korean War captures, became National Archives Record Group 242 Seized Enemy Records. When I started working with the captured records in 1979, our focus was entirely on describing records that were already filmed and returned. Only gradually did I and my later staff who joined the section realize that a fair number of originals remained. The largest single collection consisted of about 5,600 oversized daily situation maps that were prepared by the German Armed Forces High Command. These maps were huge, wall-sized maps, average size 5 feet by 8 feet or 6 feet by 6 feet, which represented a duplicate set of the same maps that you see in the newsreels and photographs of Hitler and his generals hunched over in earnest conference. The maps were retained not because they fell in any of the exempted categories, but because the National Archives lacked the proper technological means of reproducing acceptable copies. For neither microfilm nor photocopies provided the necessary scale or color. And the color information on these maps was crucial to understanding the content that they provided. In 1994, two significant developments took place. First, with German reunification, the U.S. State Department closed the Berlin Document Center, transferred all the original biographic collections of the Nazi Party and its affiliated organizations to the Bundesarchiv. The National Archives, meanwhile, received the nearly 37,000 microfilm rolls that reproduced those original biographic collections. The second development saw the opening of Archives 2 in College Park, Maryland, whence the captured records section moved in 1995. Archives 2 offered physical and technological facilities previously unavailable at the main building downtown. And in the case of those oversized maps, it had the necessary camera equipment and physical space that we could properly lay out the maps, reproduce them, finally give them adequate preservation treatment, and prepare them for return to Germany. What we produced, by the way, was 8.5 by 11 color slides for each of these maps. Normally 2 to 4 were required for each of these maps. By the mid-1990s, too, the intelligence and cryptographic materials that had been exempted earlier had also been declassified almost entirely, and thus the stage was set for the final phase of restitution. From 1996 through 2006, my principal job involved coordinating the final return of about 1,100 cubic feet of records during those years. In addition to the maps, these included a fair amount of books and publications, either collected in or prepared for occupied countries under German rule. And as part of a program initiated by Dr. Peterson, archivists from 6 European countries claimed these publications for their own archives. Another feature of the final phase saw the completion of a unique Cold War legacy, the Smolensk Archive, a collection of documents created by regional Communist Party authorities in the Smolensk Oblast during the late 1930s. The odyssey of these records began with their capture by advancing German forces in 1941 and continued with their seizure by advancing American forces 4 years later. They were brought to the United States for exploitation and historical research, and following microfilming, were offered for return to the Soviet Union in the mid-1960s. The offer, however, was rejected. As published studies had revealed, the Oblast records exposed the wide gap between party rhetoric and grassroots realities in Stalinist Russia. Soviet authorities, therefore, in part at least, denounced their own records as either bourgeois falsifications or containing post-war bourgeois falsifications inserted into the records, and they were therefore unworthy of restitution. In the late 1990s, the National Archives renewed contacts with the Russian government, which culminated with the final return of the Smolensk Archive in December 2002. Regarding access, the U.S. Army began to permit unofficial research among German records as early as 1953. By 1972, all but about 2% of the 30,000 microfilm rolls of captured German records at the archives were open for research. Most of the remainder were restricted for reproduction rather than access due to privacy concerns. When we accessioned the Berlin Document Center's biographic collections, again amounting to 37,000 additional rolls, we wrestled with the privacy issues among these materials, but ultimately concluded that as these collections had been made available for research while in Berlin, the National Archives had to maintain that level of access. There are today virtually no restrictions on the captured German records at the National Archives. They are essentially all open for research. This is, of course, a bare bones account of a protracted, complex process. I'll be happy to expand on any of this in the question and answer session. As a final note, I would caution against treating the story of the return of the captured records as a template for seized Iraqi or any other nation's records. Rather, we might consider whether there are some elements of the German records experience that retain relevance for today and for the future. Among these, that the process evolved over an extended period, that considerations of principle, political pragmatism, technological capabilities, and necessary cooperation among stakeholding parties all played significant roles in that process, and that while American authorities always reserved the final say, the Federal Republic of Germany earned the restitution of its documentary heritage by demonstrating its stability as a political and military ally, by its commitment to parliamentary democracy, and by its willingness to confront its past. Thank you.
Thank you, Tim. We've now heard from a lawyer and an archivist. Now we're going to look at it from the point of view of a researcher. We have with us Conrad Lawson. He's a PhD candidate at Harvard University who's writing a dissertation tentatively entitled Treason and the Reconstruction of Nation in East Asia, 1937 to 1951. For his dissertation, he's done research in several collections of conflict records, including the captured North Korean documents that are held here at the U.S. National Archives, Chinese Communist Party documents held in Taiwan, and documents from the Chinese nationalist government and Japanese occupation held in Shandong Provincial Archives in China. So he's looked at 3 different kinds of captured records in 3 different kinds of holdings. And by the way, he's founder of the East Asian History blog, which is called froginawell.net. Conrad, what's the frog in the well today?
I mean, as related to archives?
Of course.
It's the lack of perspective when you're limited to national archives in one area. For example, Taiwan scholars not having access to the Chinese archives, I would say.
Okay.
Did you have the question?
It's yours.
Okay, great.
What we've asked him to do is, what do researchers need to keep in mind when using captured records, and what access conditions have you encountered, and did you think they were appropriate?
So when I go to a normal archive as opposed to a conflict archive, there are at least 2 or 3 agents or components of the archival system that I need to keep in mind when I look at any given document. There is the person who produced the document, whether this is a state or a non-state actor, and there is the person for whom the document was created, the audience, if you will, or if it's a report, for example, by a communist functionary for his own local or provincial party official, it's the recipient of that document. And then finally the archive and the archivists and the curatorial process itself. These are 3 kind of actors that as historians we always need to keep in mind. But with conflict archives, such as the captured North Korean documents from the Korean War, or with communist documents from China that now reside in collections in Taiwan, such as Chinese intelligence archives, or with nationalist government or Japanese documents in the Chinese archives of various provinces and at the national level, there are at least 2 other components to this story that I have to keep in mind whenever I look at it as a historian. One is the fact that there's now another mediating process here, and that is the archive of the United States, for example, acts as a mediator between me and my access to particular documents, and also as a curator of those documents. But what conflict vectors, we have one more actor, and that is the capturing state, the state who has seized these documents in a conflict. And related to that is the context in which those documents were captured. So as we saw in the Iraq case, for example, there's a specific context in which the various types of documents were collected, in some cases in private hands, in some cases in military hands, at different stages of the process. They had different objectives. In the same way, as a historian, when I look at these historical documents, the context of their capture is extremely important to understanding in what state they are and in what part do they play in a larger whole? So to be a little less abstract about this, let's take the captured North Korean documents that are now accessible in Record Group 242 of the National Archives, Archives 2. Those documents contain a mixture of materials from the end of World War II in 1945 to 1950, when the outbreak of the Korean War, and wartime documents from 1950 to 1953. And there are almost two separate kinds of contexts here. One is the kind of the immediate post-battle situation where they grab lots of military documents specifically in the site of a battle. But a lot of the documents that have been most useful to me as a historian are rich collections of documents that were gathered almost seemingly without any logic when a city, a town, or an outpost was taken by the United States forces as they moved into North Korea during the Korean War. And as a result, you get an extremely rich but also a very diverse archive with little seeming pre-existing order to them. You can almost feel you can almost relive the experience of the soldier of the unit going into a village, and when I open that box, I might see prison rosters in the same box together with baby photos that were captured in a nearby civilian home. It's literally that diverse in the case of the North Korean documents. The context is equally important in the case of some of the documents I've seen in the intelligence archives in Taiwan and in the communist archives in provincial government of Shandong province in China. In those particular cases, we're looking at a civil war case, not an international conflict, but still I would say that many of the same kinds of issues of conflict documents are at play, where you have a civil war between communist forces in China and national forces in China, both during and after China's occupation by Japan from 1937 to 1945 and extending into the post-war period. So the context in which they are captured is extremely important for historians to keep in mind, but it also has an impact on the variety of materials that you get, but also the questions about how those materials should be handled decades after the event, for example. What is to happen to the baby photos from North Korea as opposed to raw military field reports, for example? Finally, I would just want to say that another aspect that's quite unique for the historian is the relative lack of a filter in terms of privacy issues and classified versus non-classified. As a historian, my interests do not always align with those of the archivist or with the state who that archivist works for. Nor am I necessarily an activist or representing a particular national group or someone who was a victim of a particular conflict. As a historian, it benefits me to have access to the widest variety of materials from the widest variety of perspectives. So each time I go into the archive, those conflict records present an amazing opportunity, but also a moral challenge for the historian as well. Because, for example, the North Korean captured documents in Archives 2 contain party card members, addresses and reports submitted by informers informing on their neighbors, for example. In the archives that I've looked at, the materials I've looked at in Taiwan, I'm seeing individual reports of so-called treason elimination squads who are carrying out executions or assassinations or killings of various kinds of an extremely violent nature. And those materials sometimes were denied to me in the provincial archives in Shandong, not necessarily because they posed a threat to Chinese security, but because they also have this other aspect of the protection of the individuals who are mentioned in the archival documents. That filter is often removed or at least reduced to a great degree when I'm dealing with conflict records, either because the archive which is holding the documents does not have the personnel and the manpower to go through them all. And that was both the case in Archives 2, where we're dealing with a very large collection of North Korean documents that are in Korean language, as well as for Japanese documents in the Chinese Communist Party provincial archives, where I was told by, for example, a Shandong archivist, the reason why we can give you a lot more access to Communist Party documents of a highly controversial nature than documents requested from the so-called enemy and puppet records collection, which is what they call the Japanese and the nationalist government records. I said, why don't you want to give me more access to this latter collection rather than the former, as it seems from the Chinese government's perspective, you want me to not see all the nasty live burials of reactionaries, but you would want me to see all the horrible things the Japanese are doing, for example. The answer he gave me was that we don't have qualified archivists to evaluate what are in these materials. And so from a historian's perspective, the filter is removed. Finally, I was asked before I came here just to comment about the access I was given to the materials in the various places. And I would just say that the experience at Archives 2 was absolutely fantastic. Those captured North Korean documents are now the single most valuable source for anything and anyone who wants to do research on Korea from 1945 to 1950. It's pretty much the only serious primary resource out there for us. In the case of those same documents are not as accessible in Korea, despite the fact that they have been transcribed and sometimes reprinted in multi-volume sets. And due to national security law in Korea, Koreans cannot freely access those same documents within Korea that they could easily travel to Washington, D.C. to view themselves. And in the case of the Taiwanese archives, I was also given an amazingly free and open access to the documents, with one unusual caveat, and that is that the archive itself does not have its own web page. It does not exist anywhere online. There's no book or guide or catalog to it. It's a word-of-mouth kind of thing. And because I didn't have the right connection via word of mouth, I literally called the Report a Spy number in Taiwan. It's this kind of 911 number you can call to report suspected communist spies. And I asked for the archive. And that was how I got there. They connected me to a number of different people. So their access once you're within the doors of the archive was fantastic, but the archive itself is a relatively obscure institution. Thank you.
Now we are finally come to Iraq. Bruce Montgomery has probably been involved with Iraqi records more consistently for the past 20 years than anybody else in the United States. Bruce is the faculty director of archives at the University of Colorado at Boulder. He founded the university's Human Rights Initiative. He was a founding member of the International Federation of Human Rights Centers and Archives. The center in Boulder held the records of the Anfal and other materials that were seized in Iraqi Kurdistan in the first Gulf War, and now holds the microfilm copy of those. He's written extensively on those records, the Anfal files, and he's got a forthcoming article, which I can't wait to read, which is why the Iraqi Jewish Archive should not be repatriated to Iraq. We've asked Bruce to talk about when an archive holds a body of captured records. How does the archivist determine what records can be made public, which need to be protected because of privacy rights or national security issues? And what lessons could we learn from your experience with the Iraqi police records that made up the bulk of your holdings?
Thank you, Trudy, and thank you to the Woodrow Wilson Center for this session. I'm going to talk a little bit about how we acquired the Anfal records. Then I'm going to talk about the agreement under which we acquired the documents, access issues, problems with access, and how we attempted to resolve those particular issues. Now, the Anfal records were seized in the March 1991 uprising of the Kurds after the first Gulf War. They were seized by the Kurdish Democratic Party, and primarily by the Kurdish Democratic Party and the Party of the Union of Kurdistan. And when they initially seized the records, they saw them primarily as a great cache of intelligence to find out who the collaborators were with respect to Saddam Hussein's regime, which had been carrying out a policy of what came to be known as genocide, the Anfal genocide, in the middle to late 1980s, to punish the Kurds for their siding with the Iranians during the Iran-Iraq War. After their seizure, a number of people got involved. Human Rights Watch got involved. A fellow by the name of Peter Galbraith from the Center for Foreign Relations got involved. They thought these documents ought to be flown out of Iraqi Kurdistan to the United States for intelligence purposes. And that eventually occurred. The Pentagon, the Center for Relations Committee provided the funding, and then the Pentagon flew the records to Washington, housed them at the National Archives, while the DIA digitized the documents and at the same time formed an unusual relationship with Human Rights Watch to allow them to come in and examine the files for a possible case of genocide under the Genocide Convention, 1948 Genocide Convention. After the documents were digitized, I had been following this case since they were seized, and the story appeared in the Christian Science Monitor, the New York Times, and other venues. And through contacts through Colorado senators and the Senate Foreign Relations Committee and Human Rights Watch and representatives from both the KDP and the PUK, we finally made headway to acquire these documents. But it's important to state that all parties involved in these documents and the seizure of these documents wanted to make them accessible. They were not concerned about restricting them. They wanted to make these as accessible as possible to expose the crimes of the Iraqi regime. So we acquired these documents under the explicit expectation that the documents would be made available as soon as possible and with minimal restrictions. And the agreement that was forged was done by the Senate Foreign Relations Committee. At that time, it was the co-chairman were Senators Joe Biden and Jesse Helms. And under the agreement, that the Kurds retained ownership over the documents, and they were to be in our custody. And if the Kurds demanded their return, then we had to honor that request, and the documents would be returned. But we had both the physical documents, 18 tons of them, and I also acquired a copy of the digital files from the Defense Intelligence Agency's Document Exploitation Division. So we had the physical documents and we had the digital files. And with the acquisition of all this material, we held it in an off-site location, an undisclosed off-site location. The expectation was to make them accessible as soon as possible with minimal restrictions. We wrestled with how we were going to do this. Documents contained a lot of sensitive information with respect to informant files, names of people who had been executed, the names of course, intelligence agents and so forth, their salary data, Arabization program, mass executions, all of that. So we originally formulated kind of a more or less of informal access protocols where if someone came, was requesting information from us, wanted to see the documents, we would ask for basic information, their license, photo ID, name of employer, things of that sort. We would check their employer, whether this person was legitimate or not. We would run it through. We had a couple of people who worked in Colorado Springs at the time, which were former Kurdish Peshmerga. We would run the information through them. We'd run it through Human Rights. We would run it through as many people as possible to try to determine whether these people were legitimate scholars or investigators, lawyers, or journalists, or whoever. That, as you can imagine, that was a rather arduous process, inexact process, not systematic. Most of the people that were coming to us at that time were journalists from around the world, were human rights lawyers working for various international organizations that were trying to gather evidence for a formal case of genocide against the Iraqi regime. The State Department was very interested in these documents as well. There at the same time, they were collecting information for perhaps an eventual trial of the Iraqi regime. But they were mainly concentrated on the physical documents. That's what they wanted to use. That's what they wanted to see. At that time, there was no particular demand to see the digital files, which we had, and we had not yet got them up and running until about 2006, 2007. So we eventually developed a another set of protocols. The physical documents themselves were returned to Iraq in 2005 through the State Department to be used in the trials of Saddam Hussein and his senior leadership for the on-fall crimes. So we went to another form of access altogether, and most universities that receive federal funding to conduct research involving human subjects use a process that's called the Institutional Review Board. That requires researchers to write a proposal. It's passed through monitoring panels that evaluate the legitimacy of the research that scholars want to do that involve human subjects. And so we went with, we instituted that access protocol. And the IRB, the Institutional Review Board process, initiated really after World War II, stemming from the Nuremberg trials, the thalidomide incidences in Europe, where women were given an experimental drug as a sedative, and birth defects occurred. This happened without their knowledge. The Tuskegee syphilis case involving several hundreds of rural black Americans that were traced for a period of years, for many decades, starting in the 1930s. I think that case ended in 1972, 1973, so without their consent or knowledge. So all these unethical cases, clinical trials and so forth, gave rise in this country and abroad to an institutional review process where people have to submit their research to rigorous review, and then have their research protocols monitored throughout the process. So this is where we have gone, and this has actually worked very well for us. Some people complain that it's a bit too rigorous, particularly historians, but those who are involved in anthropology, sociology, and the other behavioral sciences are used to this process. And this is necessary. It's a risk-benefit model, and if the benefits outweigh the risks, then you grant access. But that's not made by us. That decision's not made by us. It's made by the institutional review process at people's own universities, and then they submit that to us, and then they gain access to the digital database, and that's how we now manage access to these particular documents. Thank you.
Thank you. Now, I'm going to go back down the panel once and ask them if they have other comments or if they want to ask each other questions. Doug?
Actually, I wanted to start off with a question for a researcher. I was very interested in what you were mentioning about looking at documents where you can almost tell how they were being captured. And is there a preference as a historian and as a researcher? Is that a better way for captured records to be basically in that order in which they were captured? Is it helpful if those capturing them have organized them in a way that they think is useful, or is that yet another obstacle and another intermediary? I'm sort of interested in to the extent that the policies on how those documents are captured and preserved.
The context of the capture of the North Korean documents, I think, is a little unusual compared to what I saw in, for example, in China or Taiwan, because I think that whereas the Chinese soldiers, whether they were communist or nationalist, capturing their enemies' documents, could read the language of the target, so they knew what they were looking at. I wouldn't be surprised if some of the Americans who were capturing these documents didn't know if they were looking at a Korean document or a Japanese document, because there's a lot of Japanese colonial period stuff in there as well. I found a whole Japanese library in there, which may have belonged to a Korean who could read, Japanese, which most of them could back then, but it could have also belonged to, who knows where it came from. But the North Korean documents are, as you say, they're organized by shipping. They preserve the original order in a sense. So you're likely to get documents from the same area and the same time period clustered together, except when, for example, they went into a place and I get all the prison records going back many years for a particular town, and then I also get the local municipal office, and then I might get the local kids' homework in their math class. But the lack of skill or curatorial ability of those people who were actually capturing those documents in North Korea may have yielded a relatively low military value, but they have been a boon for historians, because where else am I going to find a homework, the homework assignments for a child in elementary school in North Korea, or them practicing their favorite, communist songs on the back pages of textbooks, for example. And it's just the kind of rich material that, if it weren't for the accident of the inability of whoever captured this document to distinguish between geometry homework and artillery, thing, is really, really valuable for historians. So I think in that particular case, retaining that order, it has its pluses and minuses, and I'm fairly neutral as long as it's well cataloged. Which it somewhat is, thanks to the work of both American and Korean scholars. But it really is an unusual, I think, collection of conflict records.
Tim, is there something you want to add now that you've heard this discussion, or ask questions of your other panel members?
I guess I could make one general observation. I have the tremendous advantage here of my subject matter, talking about a process that is effectively completed. It has been through a 65-year process, as I indicated, and everyone else is dealing with issues that are much closer to the present and are still ongoing. So one interesting contrast I would make with regard to Conrad's remarks, the battlefield capture records, there's something similar, though not nearly as interesting, in World War I. World War I records of the U.S. Army Expeditionary Force, the G2 section, and its battlefield sweepings of captured German documents, while they have very little socio-political context, because we're not in the homeland. You're just battlefield sweepings of frontline trenches. And in that case, the organization of the records was done after the war by G2 officers, taking the material and looking at who created the record and then arranging it by organizational hierarchy thereunder, rather than by where it was captured or what unit, because all the highest level units that were represented were division level. So you have an interesting parallel, but not quite the same there. I would have one question for Doug, and that would be, when the Allies seized the German records, they very specifically cited the 1904 Hague rules, I believe, entitling them, as you mentioned, to seizure of records in the course of military operations in order to facilitate our own military operations. But for those seizures after June 1st, 1945, which is really the bulk of much of the material, they justified it on the basis of basically their own legislation. Representatives of the United States, Great Britain, and Russia, I believe, the Allied Control Commission passed a number of some items of legislation which legitimized their own seizure of the records. But I wondered if that's not debatable in an international arena.
Yeah, it's actually very interesting, because it kind of goes to the point that there's no typical conflict, and each individual war has its own special complexities. And so in that situation, what happened, and actually covering this, there's an excellent legal opinion from 1947 from the Army Judge Advocate that goes through the issue. They were asked, we have these historical German documents that we have here. Is it okay in relation to international law for us to remove these? And it was done by a colonel in the Army who went through very carefully the Council Control legislation, the Potsdam Agreement, the 1907 Hague regulations. And the tricky thing about the German, the end of the German war, is that the U.S.'s view is that that period after that was not actually a belligerent occupation. It was something called a deballatio. It was a situation where the whole German state essentially dissolved, and therefore there was no infrastructure left, so that it wouldn't be a straight occupation in which they would basically use the structures that are there. They would have to sort of start from the beginning and build it up. And in that situation, they did take a view that they had more power and more of a responsibility to and more authority to take records. Although it is very interesting in the that opinion that I referenced from 1947 that that was a situation in which at the end the judge advocate finds that because those records, the specific ones they were asking about, were of historical nature and had no military value, he said that would concluded that taking those out of Germany would shock the public conscience and would be a violation of international law. But it is very tricky how that works. And there is also, you see, as those started to be returned, and one of the ways the U.S. sort of asserted what authority it had over it was because they considered them U.S. Property and U.S. federal records, they had to comply with the Federal Records Act, which doesn't allow you to dispose of federal records without authority from the Archivist of the United States. And so they basically got authority to do that, and they said, we're going to donate these to Germany. And there's a backstory to that, where one of the leaders in all of this was Ernst Posner, who was an archivist who had been in a German concentration camp. He came to the United States, and he was central to the issue of capturing German records, preserving them, protecting them. And he was one of the driving forces for pushing for that use of the Federal Records Act to make the point that we haven't done anything wrong by withholding these. We are, as a matter of discretion, returning these to Germany as a donation. But we have done nothing wrong, and in fact, we followed the law. But it does rely on that special situation.
And that scheduling immediately or shortly thereafter followed the October 1952 policy paper.
Yes.
I also might add that no one was paying attention to international law during World War II. They passed the 1907 Hague regulations, and World War I occurred, and no one paid attention to the cultural property protections in the 1907 Hague regulations. The Germans and the French bombed each other's cultural institutions. They raided each other's cultural sites. They plundered, they pillaged. Then World War II occurred, and they certainly did not. Again, which proved the futility of the 1907 Hague regulations. Certainly, the Nazis didn't pay attention to the laws of war, nor did the Allies, and which is why after the Second World War they passed the 1949 Geneva Conventions, which also included cultural property protections, and then followed that up with the 1954 Hague Convention, which is solely dedicated to cultural property, and as well as its two protocols in 1954 and 1999. And then they passed the Geneva Protocol number 1 in 1977, which also had cultural property protections. So there's international law, then there's warfare, and at least during World War I, World War II, it demonstrated the utter failure of cultural property protections in the laws of war.
Conrad.
We heard a little bit from Tim about some of the conditions in the case of captured German documents for restitution. I wonder if either Doug or Bruce could comment a little bit more about other more contemporary cases of ideas out there for what kinds of conditions there might be for restitution of these documents going forward. And I'm thinking of this from the perspective of a historian, where preservation and access are obviously big concerns for the archivist, but for the historian, it's also about in unequal access. For example, one of my most frustrating experiences or things that I witnessed was being in the National Archives of Taiwan, or what they call Academia Historica, and looking at nationalist government documents from the 1930s, basically Chiang Kai-shek's orders to somebody, and sitting next to a Chinese scholar from the mainland who is in Taiwan. It's easier for Chinese scholars to come to Taiwan now, who has access to the Republican period, the nationalist government archives, and yet I watched him as he was repeatedly denied access to documents I had seen only a few moments earlier. And so this kind of inequality amongst researchers is frustrating, because it can be done on so many different ways. It's not just classified versus declassified. It can be, do you belong to this ethnic group or that ethnic group? And I'm wondering how have some of these questions made their way into the concerns of both archivists and legal scholars?
Let me take the privilege of the chair and say that right now, under consideration in the International Council on Archives is a draft set called Principles of Access to Archives that tries to address, as one of the principles, exactly that question. There are 10 basic principles, one general principle, then principles 2 through 8 are principles directed at researcher use, and principles 9 and 10 are access by archivists to materials to make sure that they are preserved and that the archival view on access is accommodated as decisions are made. So that's in debate right now. The comment period just closed at the beginning of this month. It now starts to go through a very long voting process. We expect a vote, I hope, in August. And of course it doesn't have teeth, but it suddenly gives us a lever that we've not had before, a basic international statement of this is the floor under which access to archives should be provided. I don't know if it's going to pass. Every country in the world gets to vote, so we'll see what happens. Okay, having said that,
Yeah.
let me go back.
Well, let me just say this. These are still very, very politically charged documents. And they're politically charged because of what's still occurring in Iraq. And there's a great deal of sectarian violence still. We don't know whether they're going to have their civil war or not. A great deal of sectarianism. The last thing we want to do is be responsible for people coming in, getting a list of informant lists, and then going back to Iraq and using that as a weapon to disappear certain people on the streets of Baghdad or Iraqi Kurdistan and so forth. Which is why we have to be very careful in who we let into this particular archive. Now, 50 years down the road, 60 years down the road, hopefully these documents can be made completely open on an unqualified basis. But at least at the present time, we have to be cognizant that these remain very sensitive records that can be misused, even in this country, and especially if they're returned or repatriated to Iraq at this particular time. My own view on that is that it would be highly irresponsible to return these highly charged documents back to Baghdad at a time when they could easily be misused against enemies of the central government and so forth. So I'm sure this is a central consideration for the State Department and maybe even the American intelligence community on deciding when these documents should be returned.
And if I could just touch on Conrad's question, it actually reminds me of a couple of things. One, it's despite all the horrors of war and the danger and the destruction that happens to the archival record during war, it is one of the small ancillary benefits that sometimes those sorts of issues of access just change simply by the documents changing hands. You're changing one government's decisions about national security for another, but sometimes those are different, and so therefore sometimes the access, a little more access is allowed when it wasn't otherwise. It also reminds me of something that when I have sometimes drawn this parallel, I've gotten in trouble a little bit, but it reminds me, the two people having two different access to the same thing reminds me a little bit of those people who are in government right now who are not allowed to look at a WikiLeaks document with everyone else on the internet. But it's, I mean, there are obviously some distinction there, but it's a continuing problem.
Anything else, Bruce?
No, I think that's it.
All right. What I'd like to do now is turn the floor to you. I'm going to take 3 questions at a time. Please tell us your name and to whom on the panel the question is addressed. And then at the end of 3 questions, we'll quit and we'll have the panel discuss and we'll come back for 3 more. This side of the room, anybody got questions? In the far back.
Yes, hello, my name is Brad Bauer, and I work as an archivist. And one question I'd just like to direct to the panelists in general, but I'm thinking of Conrad's comments about filters and everybody else in general, is how do you respond to archival materials that have been taken by individual soldiers or individuals in general as war booty, as souvenirs? I've worked at 2 different repositories where several collections from Nazi Germany that have ended up in those repositories were donated by U.S. military personnel many, many years after the war. And I worked in another repository where there were some materials like that from the current conflict or recent conflict in Iraq as well. Any comments about legal research or other issues you might anticipate with such materials?
Okay, thank you. Another question here? Okay. Laura, we've got 2 here, and then we'll stop and let the panel work on these.
My name is Stephen Shore. My question is about the archives of Imperial Japan as the American occupation moved forward, whether there was a protocol for which areas, government areas of wanted documents for, and given that the likelihood that other nations that we cannot now identify are likely to be occupied by other nations, is there any international thought of how to proceed to secure and protect the archives of a nation that another nation is about to occupy?
And my name is Kathy Diamond. I'm a Title VIII scholar here at the Wilson Center. My question is for Timothy Mulligan about, we know what was taken out of Germany and taken to the United States, and there aren't too many surprises about the materials. They've been pretty well sifted through, as I understand it. What do we know, however, about the materials that were taken by the Soviets, the captured German documents? Specifically those documents that were taken out of Berlin during the Allied bombing between 1943 and 1945 for safekeeping in the Eastern Territories. Do we know how much was taken? Do we know what happened to it? And how much is still unknown? Thank you.
Okay, so let's do it in reverse order. We've got a question for Tim. We have to shorthand an Imperial Japan, and I'll come to Conrad and Doug, and then whoever wants to take the issue of personal documents. So Tim, can you lead off?
Yes, in response to your particular inquiry, we have a pretty good knowledge of the overall scope of Soviet captures based on how the Soviet government disposed of those materials that they disposed of. That is, those materials which were given back, for example, records of the German occupation regimes and military government in occupied Russia, in occupied Poland. Those were restituted by the Soviet regime to those East European countries, which of course are East Bloc countries. And so those became part of their archives, and to varying degrees, they were described by archivists of those countries. For example, the Poles did a magnificent job of describing their holdings of German records that relate to the German occupation of Poland. The Soviets also returned records to the German Democratic Republic, which have now been incorporated back into the Bundesarchiv. So we have very good control of those. There are other records that remain in the Soviet Union, or in Russia, records seized by the Soviet Union, and some of those have been described. There is a major archive in Moscow where German archivists were allowed access to catalog those holdings. And that included many high-level materials, German government, Hitler's chancellery, anything that was a kind of a show item, naturally wound up in this archive in Moscow. But there are other archive centers in Moscow and elsewhere in Russia that hold German records that we do not know about. Therefore, this is an open question. It is not resolved at that end as it is at this.
Okay, Conrad, can you talk a little bit about Imperial Japan, and then we'll ask Doug for a legal opinion?
Yeah, it's a bit embarrassing, actually. I'm officially a Japan historian, and yet I haven't looked a lot at captured Japanese documents. So I think that Doug and Tim especially would have more to say about their state. I can say that there's a book coming out, I think this summer, by John Abel, which has a whole chapter on the capture of the Home Ministry documents at the end of World War II, Japanese documents. The only Japanese documents I've seen from World War II are Japanese documents that were captured by everything from Chinese resistance forces to Filipino resistance forces and various documents of that nature, not documents from the home islands. Mm-hmm. So I just can't comment about that.
Yes, I can't think of the author's name, but there's also a very good article done by a Japanese scholar on the capture in Southeast Asia and what came back. Yeah.
As far as captured Japanese records that we have, there are very few that are on microfilm. First of all, many fewer Japanese records were seized by American forces than were seized in Germany, because Germany was physically overrun, and the Germans had no chance to dispose of the records. Japanese had time to do whatever they might want to do with records they might not want to be seen. Several thousand feet of Japanese records were brought to the United States, brought to Washington, where they were exploited, and after a certain amount of time they were returned, because there was not at the time a lobby, as there was for Europe, among historians, to make sure we get copies of this so that it's going to be here and available to American historians. It would seem that American Asian scholars were not as organized, or they didn't have access to the same funding to offer to begin microfilming those records. And the result was we have some records, especially Japanese foreign ministry records, that are available on microfilm. We have a very small number of Japanese Army and Navy records. But basically, there is no comparison between the captured German and the captured Japanese records in National Archives custody.
Okay, Doug, over to you on both the question of looking forward and seeing what could we do as somebody's going into the country, and also what about the personal captures?
On the first question, preparing for a country that might be occupied, it's a crucial one because, as Bruce was saying earlier, you can't rely on the fact that the rules are going to be applied with any carefulness. And as Conrad was saying, the soldiers moving through, they're not going to often know that it might be in a foreign language. They're just going to be sweeping these things up. And the way that one of the only ways forward is to think about it pragmatically, and to think about ways in which the interests of an invading force and an occupying force might be aligned with the interests of preserving these records. And there's a lot of overlap, and there's a lot of synergy there, which in sort of the literature on document exploitation in the military, it's getting more about you need to preserve context. You need to take a picture of where this thing was rather than just throwing them all in a plastic bag. There's another aspect of it that under the law of armed conflict, there is this sort of principle of distinction, and it often gets looked at only from the perspective of the invading force, that you need to determine this is something that you can seize and this is something that you can't. But that obligation of distinction applies just as much, if not more, to the defender in a conflict. They're the ones that know what their stuff is. And ideally, what they would do would be to divide up. This is our historical stuff that has no military value whatsoever, and we're putting it here. All our stuff that has military value, we're putting it here. And the interesting thing is that an invading force also has an incentive to capture them intact in that order, to preserve context for military intelligence purposes, which has, if that were to happen, would have an effect for preserving those long term. So I think it's these sorts of things that are more movement on them and more cooperation between sort of civilian archivists and historian organizations and the military, sort of cross that military-civilian divide. I think they could teach each other some things, and I think that the state of archival records would be the better for it.
So somehow I think those archivists would be considered treasonous for sequestering their intelligence files over here and their historical files over here, pretty much giving a roadmap what to seize and what not to seize.
I mean, it's actually ideally, ideally, even an archivist would help the enemy find the records that they want, so that they wouldn't have to tear them apart in order to find what they're looking for. And on the issue of individual war trophies, it's a big problem, and I always read all of these after-action reports from JAG, from Judge Advocate Generals, on all of these conflicts, and there is always this giant section that says, if you're a Judge Advocate General in a conflict zone, you need to understand these war trophy rules, because there are limited circumstances in which war trophies are allowed, like they can get approved for maybe a weapon of some kind or some kind of but the basic rule, which needs to be ingrained and in military training, and is, but needs to be stressed even more, is that you can't do that. Not only is it bad for, not only is it unlawful, because that's either the property of the government that it was seized from, or it's United States property, and you're taking United States property, which is a crime, and it is covered by the Uniform Code of Military Justice, and that depending on what that war trophy is, and I immediately think of Noriega. There was suddenly some of his stationery and business cards were being sold on eBay not long after Operation Just Cause. The idea that taking something like that could also it could also be something that's necessary for military intelligence purposes, and you could be hurting the military that you're serving by taking those documents. But it is a continuing problem.
Doug, what does an archivist do then when they walk in and find out that they've got several important bodies of material in their holdings that are indeed war booty from some other country?
What do they do?
Yeah.
That war booty that is that belongs to another country.
Mm-hmm.
Well, I mean, I guess the problem is always that they're
Call your lawyer?
Well,
is that the first rule?
Because I working within archivists working within the government, obviously, sort of need to follow all of those procedures. But it is a problem, and the fact that certain things that were seized by individuals suddenly showing up in various sort of personal archives. Mm-hmm. I mean, maybe those need to be. Somebody needs to be notified so those can be considered and possibly turned over to.
Well, it depends whether it's a government archive or a private archive.
Let's assume it's private.
Right. Then you got a dilemma on your hands. then you contact the university counsel's office and get a reading on that.
Conrad wants to get in here.
It's one of the blessings of a historian that I don't have to worry about these problems. I just want to see it. But I would add, though, that this is actually a really good question. And Japanese soldier diaries, for example, that were often carried on the bodies of, that Americans, for example, discovered on the bodies of dead Japanese soldiers, are really a wonderful source. So there's just been a dissertation written at Princeton about these wartime diaries and comparing and seeing what we can learn about the Japanese soldier experience from them. And many of those diaries, I don't know if there are some of them in the National Archives, but I know that many of them ended up in private hands. And so from the historian's perspective, I would want to encourage, for example, if there are veterans organizations or other groups maybe who are worried about being traced back and prosecuted for having war booty, that question aside, to engage in, crowdsourced transcription or putting these in some kind of digital form. Now that it's 50 years after World War II, they have become such an amazing resource. So finding the balance between not scaring these people away and not wanting to make these materials available for future historians, and also respecting the fact that this is somebody's property. I'm hoping that there'll be some kind of solution out there for that.
Okay, let's go back to the audience. A couple more questions out here? Yes, here. Wait a minute. We need the microphone.
Get the mic so you can be picked up by the webcast.
I guess this is a question that involves policy versus practice. What does one do when an administration sends its representative out to explain the seizure of archival material, the destruction of same, and library materials and so forth, as in the Iraqi war, and call it collateral damage? Do you have any responsibility to? How do you react to that?
Okay. Other questions? Take a couple more. Yes. In the back.
Hi, James Person. I'm here at the Wilson Center. My question is for Doug. What happens for materials seized before the 1907 Hague Convention, for example? And here I'm thinking of the materials seized in 1866 by the French from Korea, the 297 volumes of the Royal Library. Under what terms did the French return these materials to the Koreans last summer? Thank you.
Okay, one more question. Yes, here's one.
I'm David Pahlke from the Conflict Records Research Center at the National Defense University. My question is for Bruce. I know it was mentioned that you have a paper coming out. Yeah, I didn't think that was my phone. It was mentioned that you have a paper coming out on why you think that returning the captured Jewish archive to Iraq would be a mistake. I was wondering if you could give us a little preview of your argument.
Okay. Let's do this chronologically. Let's work from Korea 1866 to Iraq. Doug, you want to take Korea?
Sure. Yeah. The colorful history, and just to fill it in a little bit, of these Korean royal protocols Korean royal archives that were seized in 1866 by French forces. They went back to France, so they became part of the Bibliothèque Nationale de France. And they sat there until 1975, until a Korean bibliographer and historian was looking through these collections and found these and recognized what they were, because they were miscatalogued as Chinese records. This led to a long debate and a long negotiation about whether they should be returned to Korea. And this is a sort of a unique situation, because this was one that actually went to court. A Korean cultural organization filed suit in a French administrative tribunal in 2009, saying that those were unlawfully seized, they don't belong to France, and they should be returned to Korea. And the French administrative tribunal looked at this, and they looked at the fact that this was prior to some of those laws being passed, and they just sort of pushed to the side the idea of customary international law, and they ultimately concluded, based on a combination of their view of customary international law and French law, that those Korean royal archives had in fact become not only French property, but sort of French national treasures, and therefore rejected the petition. But this sort of led to further negotiations, and what ended up happening is that France and South Korea negotiated a renewable loan agreement, so that these records, these royal protocols, were returned to South Korea, which happened in last June, as French property, but on a 5-year renewable loan agreement, with the basic idea that they're probably going to stay in Korea. But the point about that is it isn't a good solution for anybody, because it takes away those records, although they have been scanned and are available for researchers even online, but it takes that away from the sort of variety of the BNF's collection in France, while denying to Korea the one part of it that is really important to them as an acknowledgement of their ownership of their own national heritage. So it's sort of the sort of mixed solution didn't help anybody. And just to answer the very first part of that question, it is an issue of international customary law prior to the 1907 Hague Convention, and it is generally understood that the 1907 Hague Convention was essentially a reflection of what those earlier rules that were essentially accepted by state action as what the rules were. And the other question was Iraq.
Mm-hmm.
And that, I mean, it's obviously the archival legacy of the Iraq War is horrible. The figures are something like 60% of the Iraqi National Archives were lost, and it's very difficult to sort of assess how that is. It is often just looked at just from the perspective of, well, the U.S. was an occupier and it had an obligation to protect those materials. But the timing of it is actually pretty tricky. And a big portion of the archives that were destroyed in the Iraqi National Archives were supposedly and apparently destroyed by Ba'ath Party actors. They were Ba'ath Party materials, slightly historical materials, destroyed in order so that they wouldn't be useful to the U.S. And so it's very difficult to sort of look at that. I mean, it is something that, given what happened at the National Museum, given this loss of archival thing, is something that it brings more to the forefront. That if it's not, putting aside sort of international legal obligations of an invading force, you also have to think about if that doesn't cause extra resources to be put towards these things, the fallout from the failure to do so, the public affairs problems, and just the intrinsic badness of those things being destroyed, I think might lead to greater resources being sort of put towards that in the future. But that is the problem with destroyed archives, is they really are irreplaceable, and because usually they're the only copy and you can't get that back.
Let me take a point of privilege here again, then I'm going to come to you, Bruce. It seems to me that when you start to talk about the amount of archives that were destroyed, you have a linguistic issue going on here. I was in Bosnia right after the war. I was in Sarajevo. And if you talk about how many records were destroyed, you had a lot of destruction out in the agencies. But if you went to the National Archives, there was actually very little damage. There were a couple of bullet holes through volumes. I don't mean it was in perfect condition, but it was indeed intact. So you can get huge numbers of, this is the destruction in Bosnia, but you have to make a distinction between those that were actually in the physical custody of the archives and the larger picture of the records of the government or the records of the country. That brings me to my second point. As you start to talk then about the law of war, when you start to characterize archives as cultural property, one set of rules kicks in. But archives are not just cultural property. They're administrative records. And they're administrative records that are useful for governing the country as an occupying force. They're useful for reconstructing a country. And so to characterize them only under the cultural regimes that are now in place, I think is a mistake. We have to remember they've got a dual purpose in any country.
Thank you. I think we also have to remember that the Iraq National Library and Archives was specifically, as Doug mentioned, was specifically targeted by Ba'ath Party, former Ba'ath Party members who wanted to destroy any incriminating information in the Iraqi Library and Archives. It's very difficult to anticipate, for any armed force to anticipate that kind of event. As tragic as it is. Now, with respect to the Iraqi Jewish Archive, I've only just begun to research this issue. But just a little bit of background information. In the invasion, a unit that was trying to hunt down evidence or information about weapons of mass destruction was temporarily diverted to a cache of documents in the headquarters of Saddam Hussein's intelligence agency. And there they found a cache of very valuable Jewish archives, some of which dated to the 15th century, to the Middle Ages. The Iraq Jewish community is the oldest Jewish community in the Middle East. I think it has a 5,000-year history. When Israel was founded in 1948, the Iraqi government, as happened throughout the Middle East and Arab countries, persecuted the Jewish community, caused them to flee mainly to Israel. The intelligence agency, the secret police at that time, seized the private property of those who fled Iraq. They sequestered them in the headquarters of the intelligence agency. It was almost, it gives you kind of a feeling of what happened in World War II, when the Nazis plundered Jewish personal records and artifacts and things of that sort, and then planned to build a museum, a museum of an extinct race in Prague. And one wonders why the secret police seized these records to begin with. Anyway, they're private records. They're not state documents. They're not public records. They're not records of the state. They're private documents, family documents. And so the argument is that because of their status as private property, when they were seized, they ought to go back as much as possible to the descendants of these particular families, and if they can't be found, then a suitable home needs to be found for these documents outside of Iraq. I can't imagine that researchers, Jewish researchers, or other researchers will have broad access if they're returned to Iraq. So just like it would have been a mistake to return plundered Jewish records and artifacts to Germany after World War II, it to me doesn't make any sense to return stolen documents, stolen archives to the land of their destruction. And so that's the main argument I'll be making in this article.
Okay. Questions? Back to the floor. Anything else? Anyone else?
We also have a question from Twitter, if you'd like to take.
Twitter question.
Yes,
Twitter
I know.
question, wow.
Appropriately, it's a question from @PDeal. Appropriately, it's about digital archives. She asked if, largely we've been talking about paper and physical file cabinets and things that are seized. She wondered if having digital archives specifically now, as people are capturing PCs and hard drives, does that change the situation from both an archival perspective and just the perspective of conflict records?
Well, I don't think it changes the laws of war. If they're captured, if it's captured data, it's captured data, whether it's on computer, thumb drives, or whether digital forensics needs to be applied to get that kind of intelligence. Of course, our armed forces now employ a broad range of means to capture communications of the enemy, satellite data, capture of landline communications, email and cell phone communications, all as well as physical documents. So I think all of those fall under the under the laws of war in some fashion, but they may have to be updated in that respect. In terms of archiving it prevents a complicated scenario. It's very difficult to manage this stuff now. You're not only managing physical documents, you're managing documents that are on hard drives, or that are on different forms of digital communications and so forth. So you need a much broader technical staff than ever before to be able to manage this digital information and to make it accessible, and then to go through it and decide what to make accessible, what not to make accessible, what to restrict, what not to restrict, and so forth. So it's a much more complicated world that we're in now.
Doug, do you have any response to our Twitter question?
Yeah, I mean, the one thing I would add is that with the seizures of things like computers and devices like that, I think it enhances one of the problems, one of the other distinctions between organizational records and personal records, because as all of our computers are sort of covered with both of them, and this sort of gets a little bit off topic, but this I think arises a lot in, or should arise more, this sort of question in the context of things being seized in that transnational war against Al Qaeda, where there are things, the line between this is a personal document and this is an Al Qaeda organizational document is both difficult to delineate, and it also has major effects, because if this one thing is characterized as an Al Qaeda document, for example, then does that mean that some of that information or that whatever is on the document can be attributed to other Al Qaeda members? And there's the courts have sort of been challenged with this a little bit in some of the Guantanamo litigation, where in one case the government's argument was that there is this Al Qaeda record that has this person's name on it, and therefore that's an indication that person is Al Qaeda. When the details came out, and this is from an unclassified opinion, the detainees' lawyers pointed out that this document is being called Al Qaeda because it was found on the computer of someone that they're claiming is Al Qaeda, but this document is something that was downloaded from the internet. So the government's position was an Al Qaeda person downloaded it from the internet. Therefore, it's an Al Qaeda record. Therefore, this person's name is an Al Qaeda record. Therefore, this person is Al Qaeda, which I think, and I mean, it's a little more complicated than that, but it's something where it's very difficult, I think, to sort of draw that distinction. And I have a half-written paper that I will never finish. That is called War Booty, the Legal Status of Osama bin Laden's Pornography Stash, which I think is that I think captures some of those problems. Are we going to make the distinction that even that is an Al Qaeda record, or is that a personal record, which are dealt with differently?
Doug, the laws of war were set up when we were thinking about state-to-state conflict. Now we're not thinking in that terms. We may be thinking of state against amorphous groups, transnational, informal groups. Does the law of war accommodate seizures from such non-state actors?
It can. I mean, this is the sort of issue of the status of our armed conflict with Al Qaeda is, it's really hot in the sort of debates in the legal world right now, because the old system is there are two kinds of conflict. There are international armed conflicts between states, and there are non-international armed conflicts that occur within one state, and that's usually like an insurgency versus the standing government. Technically, the U.S. is considering the war with Iraq as a non-international armed conflict, even though it's occurring in a lot of different places, simply because it is with a non-state actor. There are movements to sort of create another category of a transnational armed conflict to try to establish the rules, because the problem is that for a non-international armed conflict, only a certain portion of the laws of armed conflict actually apply. And so it's that, along with some principles that are customary in international law. So I think the U.S.'s position, and I think where it would shake out, is that things seized from non-state actors in something that can be called an armed conflict, that same kind of seizure can occur as between state and state. But sort of working that out, the laws don't sort of apply very cleanly in those sorts of situations, and I think that's one of the things that's sort of being dealt with.
This is something that's covered under Geneva Protocol 2, number 2, which was passed in 1977. It deals with non-international combatants, but in that protocol, they were really talking about civil wars, like the Vietnam War, not these transnational actors, which really presents a completely new situation altogether. Under Protocol 2, I mean, if there is, they have a rather exacting definition of what constitutes a non-international conflict. You have to have a political military command. You have to occupy part of the country. You have to be able to implement, have the capacity to implement the protocol itself, which means you have to be able to respect the Geneva Accords, the conventions themselves. And so it's not quite clear what constitutes a non-international conflict or not. But again, this was drafted in 1977 before the advent of these transnational actors like Al-Qaeda and other transnational actors. So I'm not sure it quite applies. But under Protocol 2, these non-international combatants can seize documents just as state actors can.
Could I?
Oh, yeah, sure.
I just want to add one more point in response to the Twitter question about what does the world of the digital do to transform this debate. And I would just say two things, and perhaps they're obvious. One is that when we're talking about returning documents, what does it mean to return a hard drive? So that changes somewhat the question about how you could potentially eliminate part of the debate about the physicality of its location and ownership. Because once it's, we've been talking up until now about archives being microfilmed and then sending back, or digitizing and then sending it back. So that part of the question may change significantly as a result of digital archives. But secondly, most of us here have been talking about two different kinds of processes. One is the utilization of these materials by the conquering state for military strategic value, and by historians like myself for this kind of post-conflict historical analysis. But the other thing that's new, I think, with the rise of large stashes or caches of digital documents is the power of exposure is radically gone up as a result. So whereas the Nazis could show off some captured Soviet document to prove that there was, a massacre in Katyn Forest or whatever, before they actually stumbled upon the bodies, or something along those lines could be powerful. But now imagine, that on many hundreds of gigabytes level, as we have seen the United States has become a victim of. And we can see that the impact of large bodies of digital cached documents is really quite powerful.
Mm-hmm. Any final questions? Final comments from the panel?
I just might add DNA, and whether that should be considered captured information. When they capture someone on the battlefield, they take their DNA, they enter that into a database, and I just wonder whether that should be considered or maybe not captured wartime intelligence.
Mm-hmm. Anyone else? One final question in the back.
It's odd that you mentioned the DNA, because that actually circles back to the comment about the German records. I work looking for the missing from America's past conflicts. I work on World War II. It's not likely that we will have any unidentified remains from future conflicts, because all of American service members are marked with a DNA sample is taken. At the present time, though, when we're dealing with World War II losses, we have upwards of 30,000 sets of remains scattered around the world that are yet unidentified. But the government is going through a process of trying to identify them, and they use, in many cases, the German records that were discussed earlier.
All right. Thank you all very much for coming, and thank our panel.